My name is Claire Donovan, and I want to start with the texts because the texts are where everything ended. And I want you to understand from the beginning that the ending was entirely her own doing. Not mine. Not my solicitors. Not the judges. Hers. Margaret Donovan, my mother-in-law, 64 years old, retired headmistress, owner of a 4-bedroom house in Harrogate, and a self-belief so complete and so long unchallenged that it had apparently never occurred to her that a text message sent on a Tuesday evening from her kitchen could become a piece of evidence read aloud by a family court judge on a Wednesday morning 6 months later while she sat 12 feet away and could not do a single thing about it. That is where the story ends. Let me tell you where it begins. My daughter Isla is 6 years old. She has red hair that she refuses to let me brush properly in the morning, and an opinion about everything, and a laugh that fills rooms in a way that seems disproportionate to her size. She has a stuffed fox named Gerald that she has carried everywhere since she was 2, and that is missing one eye and both its original ears, both having been replaced by me with craft felt in approximate but not exact colors. And she does not care about the imperfect ears, because Gerald is Gerald and Gerald has always been Gerald, and the ears are beside the point. Isla's father is my husband Patrick. Patrick Donovan is the only son of Margaret and the late Robert Donovan, and he grew up in the shadow of a mother who had spent 30 years running a primary school and had brought to the raising of her own child the same quality of absolute authority she brought to the running of her school, which is to say completely, and without meaningful consultation of the people most affected by her decisions. Patrick and I married 5 years ago. Isla was born the following year. For the first 3 years of our marriage I managed Margaret the way I managed difficult things, with patience and good humor, and the particular willingness to absorb small indignities for the sake of a larger peace that I have since learned is not a virtue but a habit that requires examination. The small indignities accumulated. The way Margaret referred to Isla as my Isla in conversation, a possessive that was so consistent it had stopped sounding like affection and started sounding like a claim. The way she arrived at our house without calling first, and rearranged things in Isla's room, because the layout was not optimal. The way she offered opinions about Isla's diet, and Isla's sleep schedule, and Isla's educational development with the confidence of a woman who had spent 30 years being the authority on children and saw no reason to stop now, simply because the child in question was not hers. I managed all of it. And then Patrick and I went through a difficult period. Not a separation. Not the end of anything. A difficult period of the kind that marriages go through when 2 people are tired and stressed and not communicating well, and are temporarily losing sight of each other in the fog of ordinary life. We sought counseling. We worked on it. We are still married and we are better than we were. And that is the truth of it. But Margaret did not see a difficult period. Margaret saw an opportunity, and she hired a solicitor. I found out about the solicitor the way I found out about most things Margaret did that were designed not to be found out about until they were too far advanced to stop easily. Through Patrick. Not because Patrick told me directly, but because Patrick was not built for secrets the way his mother was built for secrets, and he carried the knowledge of what she had done for 4 days before the weight of it became too much. And he sat down at the kitchen table on a Sunday evening and told me. He told me that Margaret had consulted a family law solicitor in Leeds, that she had done this 6 weeks ago, during the worst week of our difficult period, when Patrick had spent 3 nights at his mother's house, and the atmosphere between us had been at its lowest and most uncertain, that she had instructed the solicitor to investigate the possibility of a grandparent applying for a child arrangements order in respect of Isla. I looked at him. A child arrangements order, I said. He looked at the table. She wants to formalize her relationship with Isla legally, he said. She is worried that if things between us deteriorate further, you will stop her from seeing Isla. and she wants to have legal protection in place before that happens. I sat with that for a moment. I said, Patrick, has there been a single occasion in Isla's 6 years of life when I have prevented Margaret from seeing her? He said, no. I said, has there been a single occasion when I have suggested I might? He said, no. I said, so your mother has hired a solicitor to protect herself against something I have never done and have never suggested I would do? He said, I know. I told her that. She said she was being cautious. I looked at the kitchen wall in front of me. Cautious, I said. He said, Claire, I am sorry. I should have told you sooner. I did not know how. I told him I understood why he had not told me sooner. I told him I understood why he had not told me sooner. I told him I was not angry at him. I told him both of those things, and I meant them because Patrick was not the architect of what his mother was doing and punishing him for her decisions was not something I was willing to do. What I was willing to do, what I drove to the following Monday morning, was a meeting with a family law solicitor of my own. Her name was Diana Walsh, and she worked from an office on the Hedgerow in Leeds, and she had been practicing family law for 22 years, and she had the quality I had come to recognize as essential in a solicitor handling something this personal: the ability to hold your situation with care, without letting the care compromise the clarity. I told her everything. She listened and made notes and asked sharp questions, and when I finished she looked at her notepad for a moment. Then she said, a grandparent applying for a child arrangements order in England faces a significant legal hurdle. They do not have an automatic right to apply. They must first seek permission from the court to make the application, and permission is not automatically granted. The court will look at the nature of the relationship between the grandparent and the child. Then the reasons the application is being made, and whether there is genuine welfare concern that justifies the court's involvement. I asked her what that meant in our situation. She said, it means Margaret needs to convince a court that her application is necessary, that there is a real risk to her relationship with Isla that the court needs to address. And given what you have told me about the history, the consistent access, the absence of any restriction, she is going to struggle to establish that necessity, unless she can point to something that suggests the risk is real. I thought about that. Then I said, she is going to try to create the evidence of risk if she cannot find it. Diana looked at me. She said, that is a possibility we need to prepare for. I drove home thinking about Margaret and her solicitor, and the 6 weeks she had spent building something while I was living my ordinary life unaware. I thought about the texts Patrick had mentioned, the ones Margaret had sent him during the worst week of our difficult period, the ones he had described as intense and that he had not shown me, because he had been trying to protect both of us from the full temperature of his mother's feelings about our marriage. I thought about those texts, and I made a decision. I asked Patrick to show them to me. Patrick showed me the texts on a Monday evening. He handed me his phone with the expression of someone handing over something they have been holding carefully, and are relieved to put down, and I scrolled through the thread from the beginning, from the first message Margaret had sent on the Tuesday night of the worst week, and I read every word with the focused attention of someone who understands that what they are reading is not just a record of a difficult week, but a map of what someone had been thinking and planning and building, while the person most affected by the building was asleep in the next room. The texts were extraordinary, not in a good way, in the way that things are extraordinary when they reveal the full unfiltered version of something that has previously only been visible in its managed form. Margaret in conversation was composed and precise and careful in the way of someone who has spent 30 years in a professional role that required the management of impression. Margaret in text messages to her son at 11 o'clock at night was something different, unguarded, urgent, certain in the way of a person who has made a decision and is now focused entirely on executing it. The first message said, Patrick, you need to think very carefully about what this woman is doing to your family. I have watched her for 5 years and I have never said anything because you asked me not to, but I am saying it now. She is not the right person for you or for Isla, and you know it. The second message said, I have spoken to someone. A solicitor. There are things we can do to protect Isla, regardless of what happens between you and Claire. I need you to understand that Isla's welfare is the priority here, not your marriage. The third message, sent at 12:47 in the morning, said, if Claire tries to take Isla away from this family, I will not allow it. I have the means to fight this and I will use them. Patrick, you need to decide whose side you are on. I scrolled further. There were 11 messages in total sent over 3 days. Each one building on the last. Each one moving from concern to certainty to what I could only describe as a plan being assembled in real time by a woman who had decided that the difficult period in her son's marriage was the opening she had been waiting for, and was not going to let it close without using it. The 9th message said, I spoke to the solicitor again today. She says if we can demonstrate that Claire is creating an unstable environment for Isla, the application becomes much stronger. Think about what you can tell her that supports that position. Think carefully, Patrick. This is for Isla. I put the phone down. I looked at Patrick. He looked at his hands. I said, she is asking you to provide evidence against me. He said, I know. I said, evidence that she can use in a court application to take my daughter. He said, I know. Claire, I know. I did not give her anything. I want you to know that. She asked and I did not respond to that message. And I did not give her anything. I believed him. I knew Patrick well enough to know when he was telling the truth. And he was telling the truth. He had not given Margaret what she asked for. He had sat with these messages for 4 days and then told me because the weight of them was too much and because Patrick, whatever his mother believed about whose side he should be on, had made his choice, and his choice was his family. His actual family. The one in this house. I picked up my phone. I photographed every message in the thread. Every one. Timestamped screenshots saved to my cloud account, and emailed to myself and forwarded to Diana Walsh that same evening with a message that said, I think you need to see these before we decide how to proceed. Diana called me the following morning at 8:15. She said, Claire, I have read the messages. I need you to come in today. Diana's office on the hedgerow felt different that Tuesday morning. Not the room itself. The same ordered desk and the same view of Leeds city centre, and the same quality of focused, professional attention that I had found reassuring on my first visit. What was different was the atmosphere between us. The first meeting had been introductory. 2 people establishing the shape of a situation. This meeting had the quality of people who have seen the full shape, and are now deciding what to do with it. She had printed the screenshots. All 11 messages laid out in chronological order on her desk. The way Rachel had laid out the school documents in the story. I am not telling you, and the way all the important documents in these stories end up laid out on solicitors' desks, because that is where the truth goes when it finally has somewhere to go. She looked at me across the desk. She had printed the screenshots. All 11 messages laid out in chronological order on her desk. The way Rachel had laid out the school documents in the story. I am not telling you, and the way all the important documents in these stories end up laid out on solicitors' desks, because that is where the truth goes when it finally has somewhere to go. She looked at me across the desk. She said, these messages are significant for 3 reasons, and I want to explain each one clearly, so you understand what we have. I said, please. She said, the first reason is that they establish Margaret's motivation for the application. She is not applying because she has a genuine welfare concern about Isla. She is applying because she believes you are not the right person for her son, and she has identified a period of marital difficulty as the moment to act. That is not a welfare concern. That is a personal agenda dressed as one. And a court that sees these messages will see that distinction immediately. She paused. The second reason, she said, is the 9th message. The one where she asks Patrick to think about what he can tell the solicitor that supports the position that you are creating an unstable environment. That is not a grandmother protecting a grandchild. That is a grandmother attempting to manufacture evidence for a legal application. A court that sees that message is looking at someone who is willing to construct a false case against a mother to achieve a personal outcome. That is a very serious thing for a court to see. I looked at the printed messages on the desk. And the third reason, I said. She almost smiled. The third reason, she said, is that she sent them on her phone at 11 o'clock at night to her son who kept them, and whose wife has now given them to me. Margaret, Donovan assembled a legal case against you using a solicitor in Leeds, and a personal agenda she had been managing for 5 years. And she documented her own intentions in real time in text messages that she apparently never considered might be read by anyone other than Patrick. That is not caution. That is the opposite of caution. That is the overconfidence of a person who has spent 64 years being the most capable person in every room. She has entered and has stopped accounting for the possibility that the room might contain someone more capable. I sat with that. Then I said, what do we do with them? Diana said, we wait. Margaret's solicitor will file the permission application with the court in the next few weeks. When they do, we respond with these messages as part of our formal response to the permission application. We do not need to do anything else. We do not need to build a case or gather further evidence or construct an argument. The messages are the argument. They are self-contained and self-explanatory, and they say everything a court needs to hear about why this application should not be granted permission to proceed. I asked her what she thought the court would do. She said, a family court judge reading these messages is going to see a grandmother who hired a solicitor not to protect a grandchild, but to pursue a personal grievance against a daughter-in-law during a vulnerable period in her son's marriage. That judge is going to have questions. And Margaret is going to have to answer them in a courtroom with her own words projected in front of her. I thought about that. I thought about Margaret in her 4-bedroom house in Harrogate, composing text messages at 11 o'clock at night, with the composed certainty of a woman who had spent 30 years being the authority on everything, and had never once been made to sit in a room while someone read her own words back to her. I thought, she is about to find out what that room feels like. Margaret's permission application was filed on a Thursday in October. Diana received notification the same day and called me that evening with the particular calm of someone who has been expecting a thing and is not surprised by its arrival. She said the application had been filed by Margaret's solicitor, a firm in Leeds named Hartley and Cross, and that the supporting statement was what she had anticipated. A grandmother with a close and loving relationship with her granddaughter, seeking to formalize that relationship in the context of uncertainty about the stability of the family unit. Carefully worded, professionally constructed, entirely divorced from the 11 text messages that had been sent on a phone in Harrogate at 11 o'clock at night 6 weeks earlier. I asked Diana when we responded. She said, we have 21 days. I'm going to take 14 of them, because I want our response to be exactly right, and exactly right takes time. What I am going to build is a response that does 3 things. It demonstrates the history of consistent and unrestricted access Margaret has had to Isla throughout her life. It demonstrates the absence of any genuine welfare concern that would justify court involvement. And it submits the text messages as evidence of the actual motivation behind the application. She paused. She said, I also want to do one more thing that I think will be useful. I asked what that was. She said, I want a statement from Patrick, not a statement against his mother. a statement of fact, confirming the history of access, confirming the absence of any restriction, confirming that during the period of marital difficulty he did not provide his mother with any evidence of instability on your part, because no such evidence existed, and confirming that the messages she sent him during that period are accurately reproduced in the screenshots we are submitting. I said, Patrick will do that. She said, are you certain? I said, I am certain. And I was. Patrick had made his choice on the Sunday evening. He sat at the kitchen table and told me what his mother had done. He had made it again when he showed me the messages. He was going to make it again in a witness statement, and he was going to make it without being asked twice because Patrick understood, in the way he understood things when the situation was serious enough to cut through the complicated feelings about his mother, that the choice between his mother's agenda and his family's truth was not actually a complicated choice at all. Patrick's statement was filed with Diana's response on a Friday morning. The permission hearing was listed for a Wednesday in November. I did not attend the hearing. Diana had advised that my presence was not required for a permission application, and that in cases like this, the absence of the respondent sometimes allowed the judge to focus entirely on the documents without the distraction of the emotional temperature in the room. I sat at home on that Wednesday morning, and I took Isla to school, and I watched her disappear through the school gate in her red coat with Gerald the fox under her arm, because Gerald came to school on Wednesdays, which was a rule Isla had established, and that the school had accommodated with the gentle pragmatism of people who understood that 6-year-olds had important internal governance systems that deserved respect. I drove home. I made tea. I sat at the kitchen table and I waited. Diana called at 11:43. She said, the permission application has been refused. I said, completely. She said, completely. The judge refused permission on the grounds that there was no evidence of genuine welfare concern, and that the application appeared to be motivated by personal considerations, rather than the child's best interests. She also said something I want to read to you directly, because I think you should hear it in the judge's exact words. I said, please. Diana, read from her notes. The judge had said, the court has reviewed the text messages submitted by the respondent. These messages reveal that the applicant's motivation for this application is not concern for the child's welfare, but dissatisfaction with her son's marriage, and a desire to formalize a position of influence over the child that the respondent has never sought to obstruct. The court finds this motivation entirely insufficient to justify the grant of permission, and notes with concern that the applicant appears to have attempted to recruit her son as a witness against the respondent on the basis of manufactured rather than genuine evidence. Permission is refused. I sat at the kitchen table. Diana said, Claire, are you there? I said, she read the texts aloud. Diana said she read every relevant one. I thought about Margaret in that courtroom, the composed posture and the professional certainty, and the 30 years of being the authority on everything, sitting 12 feet from a judge who was reading her own words back to her from a printed page and arriving at conclusions that no amount of composure could redirect. I thought about the 9th message. Think about what you can tell her that supports that position. The judge had read that one too. Margaret did not call Patrick for 3 weeks after the hearing. This was unprecedented in the history of their relationship. Margaret called Patrick every Sunday without exception, had done since he left for university at 18, and the Sunday call was as fixed a feature of our weekly life as the recycling collection and Isla's Wednesday fox roll. 3 weeks of silence from a woman who had never previously managed 3 days was its own kind of statement, and Patrick received it with the resigned sadness of a man who loves his mother and has no illusions about her, and is learning, at 41, that those two things can coexist indefinitely without resolving into something simpler. I did not fill that silence with anything. Not satisfaction. Not relief. Not the particular vindication of someone who has been right about something for a long time and has finally been confirmed right in a courtroom by a judge with printed evidence. I have been right about Margaret for 5 years, and being right had not made the 5 years easier. And being confirmed right did not make the 3 weeks of silence feel like a reward. It felt like what it was. A woman in a 4-bedroom house in Harrogate sitting with the consequences of her own choices, and not yet knowing what to do with them. When she called again, it was on a Sunday 4 weeks after the hearing. Patrick took a call in the garden, the way he always took difficult calls. And I watched him through the kitchen window, the way I had watched other people in other stories make important phone calls in gardens, and I thought about how gardens had become the places where the significant things happened in the lives of people navigating complicated families, and made a mental note to appreciate mine more. The call lasted 38 minutes. When Patrick came back inside, he sat at the kitchen table, and he was quiet for a moment. Then he said, "She wants to apologize to you." I looked at him. "Not to send an apology through you," I said. "She wants to apologize to me directly." He said yes. She asked if she could come to the house. I said I would ask you. I thought about that. I thought about Margaret composing texts at 11 o'clock at night. I thought about her solicitor and the permission application, and the 9th message and the judge reading it aloud in a courtroom while Margaret sat 12 feet away. I thought about 5 years of managing small indignities and the particular patience that is not a virtue, but a habit, and the habit that requires examination. I thought about Isla, who was 6 years old and had a fox named Gerald and red hair and an opinion about everything, and who loved her grandmother with the complete and uncritical love of a child who has not yet learned to love carefully. Isla, who had not been in that courtroom. Isla, who did not know what a permission application was, or what text messages had been submitted, or what a judge had said about her grandmother's motivations. Isla, who simply knew that Granny Margaret had not come round for a few weeks, and had asked me twice why, and to whom I had said adults sometimes needed time to sort things out, and she had accepted that with the pragmatic grace of a child who trusts the adults around her to handle the complicated things. I owed it to that trust to handle this one well. I told Patrick to tell Margaret she could come on Sunday. She came the following Sunday at 2 in the afternoon. She was wearing the same careful clothes she had worn to the courthouse, I thought, though perhaps that was my imagination. And she stood on my doorstep, and she looked at me with an expression I had not seen on her face in 5 years of knowing her. Not the composed professional authority, not the managed warmth. Something underneath all of that. Something that looked like a woman who had been very certain for a very long time, and had recently become less certain, and was still working out what that felt like. She said, "Claire, I owe you an apology, and I would like to give it to you properly, if you will allow me." I stood back and I let her in. She sat at my kitchen table and she apologized. Not briefly. Not with the efficiency of someone completing an obligation. At length, and with the particular difficulty of a person who is not accustomed to being wrong, and is doing it anyway, because the alternative is a permanent fracture in something she does not want permanently fractured. She said she had allowed her feelings about my marriage to override her judgment about what was right. She said she had treated her desire to protect Isla as a justification for actions that were not justified. She said she had put Patrick in an impossible position and had used his love for her as a tool, and she was ashamed of that. She said, "I have spent 30 years being the person who knew best. I am finding out that knowing best and being right are not always the same thing." I looked at her across my kitchen table. I thought about the judge reading the 9th message aloud. I thought about Isla upstairs with Gerald the fox and her red hair, and her opinion about everything. I said, "Margaret, I have never tried to keep you from Isla. I want you to know that I mean that. Whatever happened in that courtroom, whatever you thought I was going to do, I was never going to do it. Isla loves you, and that love is real, and it belongs to her, and I would not have taken it from her. Margaret looked at the table. Then she looked at me. She said, I know that now. I said, I knew it all along. She nodded slowly. Isla came downstairs at 3 o'clock with Gerald under her arm and found her grandmother at the kitchen table and launched herself at her with the complete physical confidence of a child who has no knowledge of courtrooms or permission applications or text messages read aloud by judges, and who simply knows that Granny Margaret is here and Gerald needs to be introduced to her immediately because Gerald has been working on a new voice and Granny Margaret has not heard it yet. Margaret held Isla and looked at me over her head. And I looked back. 2 women at a kitchen table with a child between them, and 5 years of complicated history behind them, and whatever came next still ahead of them. Not resolved exactly. Not pretending to be resolved, but present. Both of them present. In the same room. At the same table. That was enough for that Sunday afternoon. That was more than enough. Isla performed Gerald's new voice for 12 minutes. It was, she informed us both, his best voice yet. She was absolutely right. She always will be.